Kelly, District 4, I move that we move C-36 into the hopper and vote it through.
Second.
And I have a second from Commissioner Hunter, so I believe you also have a proposed amendment.
There is a proposed amendment, and you know what? I'll just let my colleague from District 4 make her proposed amendment, and then I might have a couple comments.
Commissioner Dean?
I motion to amend C-36 as it is on page 80 of your packet.
All right, I have a motion to amend C-36 as it is shown on page 80 of our packet. Do I have a second?
Second.
I have a second from Commissioner Surratt. So would you like to speak to your amendment?
Yes, I'll just speak to the amendment for now. This shortens. This is the right one, right? Okay, I'm sorry. The purpose of this amendment is just to shorten and simplify. Thank you.
All right, so discussion. Vice Chair Lentz?
Once again, I'll be supporting this amendment for the reason that I have said a few times now. If the original proposers want to amend their proposal, I will support that. However, I would like to add on this one, I think the amendment is actually really good. It adds clarifying language. And as Commissioner Ginn noted, if you look at page 81 of the packet, part of the amendment strikes the original last paragraph, which attempted to assert these non-discrimination clauses also to contractors with the county. We had a number of conversations about how that was already covered in other ways, and it was impossible to enforce, so I think taking that out makes a lot of sense. The second thing that this amendment does, and you can see that the things that were added are highlighted in your packet, it adds a few other protected classifications, and it states the protected classifications much more simply and clearly. It adds semicolons, which is very important. And then finally, it adds a section or a sentence at the end, which I also think is important and really improves this. It adds on the bottom of page 80 that the rights and protections established by this section shall be liberally construed to effectuate our purpose. However, doesn't say however, I added that. But nothing in this section shall be interpreted or applied in a manner that infringes upon, diminishes, or impairs any right secured by the Constitution of the United States or the Constitution of the State of Washington. And I think this is really important. It tells a court that these protected classifications, that this language is to be liberally construed. However, it acknowledges that it does not supplant any other constitutional rights, such as freedom of religion, such as freedom of speech, such as equal protection. So I think that these changes and tweaks to this make a lot of sense, and I'm going to be supporting both the amendment and the underlying proposal.
Additional discussion on the amendment. Seeing none, we will vote on the amendment that is on page 80 of your packet. All in favor of the amendment to change C-36 to the language in the packet, please raise your cards. Count 15. All opposed, please raise your cards. Count 4. Any abstentions? And 2 abstentions. So that motion passes. So now we'll go back to discussing C-36 as amended. Commissioner Rydell-Kelly.
Thank you, Madam Chair. Commissioner Rydell Kelly, District 4. I just want to say, first and foremost, thank you to the several folks that contributed to the great amendments to make this cleaner, more effective, more inclusive, and I think really even bolder in the end. So my respect goes out to the commissioners and staff and members of the public that gave input on that. think that we are long overdue for a significant modernization of our anti-discrimination language, which has not been updated since the inception of the charter. I think that there have been many shifts and changes in the identity of folks that live in this county and in many communities here, and many changes in what constitutes a protected class. I think that's indicative of how politics and identity shifts over time, and how constitutions and understandings of what it means to be part of the body politic and community work, and in particular with employment by the government itself, wanting to be reflective of the community it serves. These are the types of things that should be modernized, and they should be updated, and they should be reflective of our values, our principles, and certainly in how we do our employment. So I'm really eager and excited about this. I feel like it has a majority position here, and I hope everyone wants to move it forward. I may reserve one or two more comments, well, one more comment, before the end of this process. I want to see if anyone else has anything else to say.
Commissioner Moore?
Madam Chair, I would like to make a motion to amend the proposal by striking the proposed language of section 9.65 and inserting the following. So section 9.65 would read non-discrimination. I too am in strong favor of robust protections.
So, what is the...
Okay.
And then point of order, you give the motion and then you get called on for debate. So you get
Do I
it.
need a second?
And then you call for the motion, you get a second or not, and then you talk to the merits of it.
Just to tell us what.
Right.
Yes.
Okay, so the motion, so 9.65, non-discrimination, in the exercise of its power or in the performance of its duty, the county shall ensure that no person is discriminated against on any basis prohibited by applicable state or federal or on any other basis not reasonably related to the accomplishment of a legitimate government purpose. After consideration of veterans' purpose, the county shall take whatever affirmative action is necessary to accomplish this person as defined in the state and federal constitutions and applicable court interpretations.
All right, so we have a motion to amend the proposal in the fashion that Commissioner Rohr stated. Do I have a second? Commissioner Herrera, second. So Commissioner Rohr, would you like to speak to your amendment?
So what this is doing is it's removing the long list, which is problematic, and putting that in the charter. It stays consistent with state and federal protections, which change sometimes every couple of years. So it's not going, the current version is problematic that it will become outdated in a couple of years. This amendment is intended to modernize the charter while keeping the language broad, clear, and durable. The current charter already includes language related to veterans' preference and affirmative action. My amendment preserves that existing language. It does not add a new affirmative action requirement. Rather than placing a long list of specific protected categories into the charter, the amendment incorporates applicable state and federal law and retains the broader protections against discrimination on any basis not reasonably related to a legitimate governmental purpose. That approach is important for several reasons. First, state and federal laws can change over time. A detailed list in the charter may become outdated. Second, a detailed list may unintentionally omit a protected category. Certain categories are named and others are not. That can create unnecessary questions about whether an omission was intentional. Third, the charter should contain charter as its foundational governing document. Similar to a local constitution, it should not need to be amended each time state or federal discrimination law changes. This amendment would update the language while preserving the broad protection already reflected in the charter. And in terms of new language added regarding new protections for women related to pregnancy, childbirth, pregnancy-related conditions and lactations. If the county council believes these additional protections for women should be stated more specifically in county policy, it can be these can be adopted, these protections by ordinance that would allow the council to update the language as laws change without repeatedly amending the charter. The charter should remain clear and be a lasting principle. Detailed policy change language belongs in ordinance. And for those reasons, I would ask you to support this amendment.
Right, discussion on the amendment. Commissioner Hopkins?
Just a quick point of information. Do we have written copies of your proposed amendment? Okay, thank you.
Vice Chair Lentz?
I have a point of information as well. Commissioner Rohrer, would you mind reading slowly?
Yeah.
Just what you're proposing.
Okay. So we would strike everything, and it would be under section 9.65, non-discrimination. In the exercise of its power or in the performance of its duties, the county shall ensure that no person is discriminated against on any basis prohibited by applicable state or federal law or on any other basis not reasonably related to the accomplishment of a legitimate governmental purpose. After consideration of veterans' preference, the county shall take whatever affirmative action is necessary to accomplish its purpose as defined in state and federal constitutions and applicable court interpretations.
But just a point of order, just for the clerk's sanity, can we have the commissioner at least email that to her for the minutes instead of having to dictate from audio and right now of that? That'd be helpful for staff.
Commissioner Rohrer, is that possible?
We're working on it.
All right, so discussion on the amendment. Commissioner Ginn?
Thank you, Madam Chair, Commissioner Ginn. I'm not against this amendment. It doesn't align with human resource best practices. It's advised to align non-discrimination language according to the Equal Employment Opportunity Commission. They state that it's important to list specific categories because broad policies are harder to enforce. It removes doubt around whether behaviors are prohibited. I totally recognize it's impossible to maintain a perfect list. However, I believe we should still try to make progress in having as complete a list as possible because of liability. It informs individuals exactly what rights are enforceable if they are subjected to an adverse action. I think there would be a lot of ambiguity and litigation questions around what constitutes discrimination if you don't list out categories, and to the point of not being able to have a perfect list. That is why it's added any other characteristic protected by law, because the point is to align it with legal categories, not to name every category, but categories that are explicitly protected by laws. Thank you.
Any additional discussion on the amendment? Seeing none, all in favor of the amendment to C-36 as submitted by Commissioner Ward, please raise your cards. opposed, please raise your cards. Twelve. And I believe that is everyone, so any abstentions, is math is not mathing. All right, so that amendment fails, and we'll go back to discussing C-36 as shown in your packet, well, as the amendment on page 80, sorry, that's what we're going back to. Getting close. Okay, so back to discussion of the amendment on page 80 of your packet. And I believe Commissioner Gann, you're next on our list. If you'd like to still say anything.
Sure. Yeah, I think I covered basically in discussing the amendment what I had covered, but I just would also add that ensuring rights and non-discrimination does not give special privileges to any one group, and maintaining outdated language in our charter is a liability. So just to echo the comments, there was a public comment received, written comment received, that aligning our local charter with current legal realities is a baseline requirement for professional governance. And I would just add that the Society of Human Resource Management, which is a completely nonpartisan professional body for human resources in the U.S., does name many of these categories in their equal employment opportunity template for employers to use. Thank you.
Commissioner Lee?
Thank you, Madam Chair. Commissioner Roby, District 3. Modernization of anti-discrimination language. Pierce County's existing anti-discrimination laws already provide robust protections based on immutable characteristics such as race, sex, religion, national origin, etc. They provide an appropriate balance by safeguarding fundamental human dignity without venturing into subjective realms. The proposed amendment is inappropriate because it relies on subjective terms and creates an unenforceable standard which invites arbitrary application, selective complaints, and potential abuse with no meaningful safeguards. C-36 distorts the principle of equal protection, prioritizing subjective feelings over objective fairness. Reject this and preserve our charter grounded in genuine non-discrimination. Thank you.
Commissioner Lewis?
Thank you, Madam Chair. Commissioner Willis, District 3. I got a little bit of notes to read from here because I cannot stay on focus. Let's see here. So my notes regarding this, and I have to excuse me, I was gone in the last meeting, so I didn't get a chance to read from this. But it's of my belief that a charter should usually establish structure, powers, and basic limits of government. C-36 instead reads like a detailed policy statement. Once language like this is embedded in the charter, even minor updates or clarifications may require another charter amendment rather than simply ordinary ordinance or policy revision. That makes the county less adaptable. The narrative behind C-36 is that the charter is woefully out of date. While that may be true textually, the county and state are not operating in a vacuum. Pierce County already maintains equal employment opportunity and workplace conduct policies, and Washington law already prohibits discrimination across multiple sectors. So the counter is, if the protections already exist, why constitutionalize them in a county charter? The proposed language is broad and includes a catch-all phrase tied to any other basis not reasonably related to the accomplishment of a legitimate government purpose. That kind of broad statement may sound noble, but it invites fights over interpretation, scope, exceptions, and enforcement. In a charter, ambiguity is a liability because courts and future officials may have to define it. The charter is supposed to be the county's governing framework, not a running commentary on every cultural or ideological dispute of the era. The more policy language that you pack into it, the more often the charter becomes a battlefield instead of a stabilized governing document. The sponsor explicitly frames this as reaffirming core values, which is exactly what critics say it belongs in policy and not in charter. The issue is not the value, it is the vehicle. A charter should define government structure, not serve as an HR manual or political value statements. Thank you.
Commissioner Ryder Kelly, for your second.
Thank you, Commissioner Randall Kelly, for, and obviously the original sponsor of this amendment. I just want to highlight that again, I feel like we're hearing some contradictory things from some folks on the commission, both that this is too vague and too specific, and that charters are supposed to be structures, but also that charters are supposed to reaffirm things, and this has been in there forever. And I just want to remind folks, it has been in there forever, it hasn't been modernized in forever, and it is keeping us up to date with practices, norms, realities, and yes, new protected classes and new identities. I also want to I think it's important to refute the point made earlier this evening in public comment by someone who is woefully misinformed, but unfortunately has a big voice in our community, who said that the laundry list that we're bringing up here is a tiny fraction of society. And I just want to note that including women who are pregnant and dealing with childbirth gets us to a very significant portion of society, and that 25% of American adults at one point in time are disabled, and a third of American adults will become disabled at one point in time or another. Folks that are otherly able are very frequently deal with bad employment practices, mistreatments, refusal to get hired, and are some of the first people terminated. Just like lactating mothers, just like women that have recently had a kid are expected to get pregnant soon. And there are treasure troves of data to support this, and it's why these policies exist and why we want policies like this in our county charter. So again, I'm deeply appreciative of the amendments that make it even better, and I wish folks wouldn't be so profoundly misinformed. Thank you.
Vice Chair Lentz?
Thank you. I just wanted to point out that the clause, any other basis not reasonably related to accomplishment of a legitimate government purpose, is already in the existing charter. The proposal simply moved it to the end of the newly listed specific protected classifications.
Commissioner Layton?
Thank you, Madam Chair. Commissioner Layton, District 7. I spoke last time this came up when we were in Gig Harbor pretty passionately, and listening to public comment time and time again, pretty hateful. Pretty hateful to sit here as a gay man and be told I'm the problem of society and spreading AIDS and STDs. That's hateful, and we still need to have protections for folks in our community, whether they be a person that is disabled, a pregnant woman, or a gay man like myself, or my husband who is in the Army, who knows what will happen eventually with the policies of our country. These things still need to happen. And I sit here politely and listen to many commenters over the last few months spew hate at me. I'm not going to speak for anybody else on this commission who might be a part of my LGBTQ family. But it is visceral, and I am thick-skinned. I've been called fag before, stones thrown at me, spit at. I'm thick-skinned. I'm 44 years old, been dealing with it. I was a gay boy growing up, and yes, I was born and raised in rural Pierce County, so I understand what that is like. And so we still need protections like this, and a charter is more than just government structure. It is protection. Charters, constitutions also enumerate the rights and protections of the people. So when I hear things like subjective realms, subjective terms, charter ambiguity, ideology, say what you gotta say. What's subjective? Thank you.
Commissioner Rourke?
So I'll be voting in opposition to this amendment. To be consistent with our state constitution, the Washington State Constitution provides broad civil right protections and includes a specific equal rights amendment based on sex. Article 1, Section 12 prohibits special privileges and immunities. It functions as a broad broad equal protection under Washington law. Article 31, Section 1 states, equality of rights and responsibility under the law shall not be denied or abridged on account of sex. The detailed list of protected classes is generally found in state statute, especially the Washington Law Against Discrimination in Chapter 49.60 RCW, rather than in the state constitution. That statute is designed to carry out state constitution civil right protections and can be updated by the legislature as law changes. So, to wrap that up, just Washington Constitution protects equal rights. The detailed protection language is handled in state law. And I know one of the commissioners also spoke to adding it in the charter, and our departments are able to interpret state law, federal law, and they must apply that to our county. There is no lack of protection as the charter stands. So I urge you to vote no.
Commissioner Consuelo?
Thank you, Madam Chair, Commissioner Consuelo, District 6. I concur with the comments from Commissioner Layton. Thank you. I don't know why I always blank. Commissioner Layton. In an ideal world, we wouldn't need this, but we're not. In an ideal world, when microaggressions and actual racism or discrimination still exists, it's necessary to have these protections in our county charter. Having experienced that myself from employment to just other areas where you may think, is there a way for me to bring this to light, or is it even worth it? I think having this in the charter will show folks that it is wrong for you to be discriminated against. And oftentimes, like Commissioner Layton said, we have thick skin, so it just bounces off, or we don't bring it up, or we don't report it. So it's quite possible that if there are numbers and data, that data is not reflective of the actual damage that is being done. So I will be a yes vote on this as a young person who has still been called a fag too. So.
Seeing no Commissioner Herrera?
Thank you, Commissioner Herrera, District 2. I will be voting against this anti-discrimination proposal because I feel Pierce County already has anti-discrimination protections in its codes and policies. I believe the original sponsor of this proposal used words like, when introducing, used words like Trumpism, used the word bigots. That right there shows discrimination in itself. And and then comments about the Mamdani in New York shows has an anti-Semitic tone. So I would say that kind of blows a hole in the whole argument here. I feel like this added amendment is not needed. We already have the protections in place. And again, speaking for myself, for someone who is multicultural, we all have at some time been discriminated against in one way or another. And it doesn't always have to be color, religion. It could be your viewpoints. It could be a lot of things. I'll share, some of my personal things since we're going there. being a person who is multicultural and conservative, some people look down on that because they feel like I should be thinking one way. Well, you know what? I have my own beliefs. I know what's right and wrong. And this is the way I feel and what I know and what I think is best for everyone, not just myself. I will never ever make decisions on me or my personal ups and downs in life, because you know what? That just comes with life. It comes with living, aging, you know, you're just growing older in life experience. So again, I will never be putting my views over someone else's and telling thousands and thousands and thousands of people how to think because something happened to me once upon a time. So again, these protections are already in place. I think Pierce County does a pretty good job of following county and state mandates on these. So I think we should look at this. We should really consider that. And, you know, if this goes to the ballot, which I hope it doesn't, I will be speaking against it at all costs. Thank you.
Seeing no additional discussion, we will move on to a roll call vote for C-37 C-36 modernization of anti-discrimination language as amended on page 80. Well, actually, sorry. Did we? Correct. Yeah, thanks. Okay, thank you. So, clerk, if you can please call the roll.
Jake Hunter,
Yes.
Martha Lance, yes. Justin Layton,
Yes.
Brenda Likens,
Yes.
Brenda Molesky,
No.
Drew O'Leary,
Abstain.
Holly Rogie,
No.
Bujana Rohr,
No.
Devin Riddell Kelly,
Aye.
Troy Sarad,
Yes.
Jen Marie Strickling,
Yes.
Judson Willis,
Nay.
Lisa Boyd,
Yes.
George Consuelo,
Aye.
Mason Fletcher,
No.
Kate Ginn,
Aye.
Sharon Hannick,
No.
Caleb Heimlich,
No.
Elizabeth Rivera,
No.
Billy Joe Heatherington,
Yes.
and Kelsey Barons.
Aye.
I have 12 in favor, 8 opposed, and 1 abstention.
All right, so that means C-36 will move on to the hopper for final consideration. That takes us to C-37, affirmation of constitutional rights and protections on page 82 of your packet. Commissioner Rydell Kelly, do you have a motion?
I move that we send C-37 to the hopper.
Do you have a second?
Second.
Commissioner Consuelo seconds. So on to discussion of moving C-37, affirmation of constitutional rights and protections on to the hopper for final consideration.
Thank you, Madam Chair. Commissioner Rydell Kelly, District 4. I'm going to keep this brief because it's very late, and this has been obviously a polarizing, controversial subject, and I'm reading the tea leaves that it's not going to get the full support that I believe it deserves. I just want to echo Commissioner Layton from a few minutes ago that charters are fundamentally not just about structure, they're about rights and protections. That's ultimately why constitutions exist at all levels of government. First and foremost, I would even say, and structure is built around our understanding and assumptions about how rights and protections work. That's why we talk about the Bill of Rights before we talk about most other things in American government. And the writ of habeas corpus and the protection of folks that are facing trial and the notion of guilty until innocent until proven guilty is profoundly important to American democracy. to the point where many people in public comment and some people on this commission have said it about our sheriff. And I find it deeply concerning that we are willing to do that quickly and easily and readily, but not about folks in our community that are currently in detention, facing trial, both documented folks and, as some people have noted, undocumented folks. I just want to add two very brief points. One thing I tried to bring up recently, but I don't think it got to, is that there is currently an active pursuit by the Department of Justice against trans women in Washington state jails and prisons, saying that because they are biological males, they must be relocated to the other gender, which is a violation of this exact understanding of rights to not have undue treatment and mistreatment. And I think that we are at a profound risk right now of these kind of rights being further stripped away at local levels of government as impacted by the federal government. So I had to make that statement. I'm not going to go on. I hope it earns support, and I understand we got a lot to get through.
So, discussion on C-37. Commissioner Roby?
Thank you, Madam Chair. Commissioner Roby, District 3. It's interesting to me that there is a selective view of who should be protected, because in my point of view, women in prison have no choice and are subjected to things. So I feel like the state has failed the women that are in the prison system, and I think it's inappropriate for a physical male to be in a locked room with a woman. So I'm just going to put that out there, because I don't think that comment was germane to this, but you had to throw it out there. So this proposal improperly injects vague, expansive terms such as undefined nations of dignity, human treatment, and procedural safeguards drawn from constitutional phrasing. This verbiage blurs the line between legitimate constitutional limits on government and a potential expansion of offender privileges, which again is interesting. No mention of victims in here, worried about the criminal's rights, which, you know, there are lots of protections for the criminal's rights, and it seems lately to the expense of victims. The wrongly elevated protections for criminals, while remains silent on victim rights. U.S. law, the 5th and 6th Amendments, already provide safeguards further reinforced by state law and the courts. Adding this clause prioritizes criminals over citizens without addressing those harmed. This is a no.
Seeing no additional discussion. Commissioner Fletcher?
Thank you, Madam Chair. Commissioner Fletcher, District 5. I spoke about this last week. It is without merit. It is entirely duplicative. And at least we're at the second round where we can vote on it. So, again, just want to reiterate that it's entirely duplicative, doesn't do anything to impact anyone or anything. So, again, I want to give full meaning to all parts of the charter. This doesn't do anything, so I will not be voting for this. Thank you.
Commissioner Rohr?
Commissioner Rohr, District 6. I'll be opposing C-37. The rights of people who are detained and incarcerated are important, and people should be treated lawfully and humanely. But this proposal does not clearly identify a problem that requires a charter amendment. The right to challenge an unlawful detention already exists under state and federal constitutions. Courts already have authority to decide whether someone is being held lawfully. For example, if a person believes they are being detained without legal authority, that issue belongs before a judge. A county charter provision does not replace the court process or expand the county's authority over the courts. The proposal also requires fair, humane, and proportionate treatment that those words are not defined. What does proportionate mean in context? It is referring to a sentence imposed by a judge, conditions in a jail, medical care, discipline in the jail, or something else. Who decides whether the standard has been met? Those questions matter because the charter is a governing document. Its language should be clear enough for the public, county officials, and the courts to understand what it requires. If there is a specific concern about jail operations, medical care, treatment of people in custody, or another county responsibility, that issue should be identified and addressed directly through ordinance, policy, budgeting, and oversight. If the concern relates to whether someone is lawfully detained or how a court imposes a sentence, that issue belongs with the judicial system. I do not support adding broad, undefined language into the charter without a clear explanation of the problem it solves, how it would be applied, and whether it could create unintentional legal consequences. For those reasons, I will be opposing C-37.
Seeing no additional discussion, we'll move on to a roll call vote for moving C-37, affirmation of constitutional rights and protections, on to the hopper. Clerk, can you please call the roll?
Martha Lance?
No.
Justin Layton?
No.
Brenda Likens?
No.
Brenda Molesky?
No.
Jerome O'Leary?
No.
Holly Roby?
No.
Rajana Rohr?
No.
Devin Rydell Kelly?
Aye.
Troy Sarad?
No.
Jen Marie Strictly?
Abstain.
Judson Willis?
Nay.
Lisa Boyd?
No.
George Consuelo?
Aye.
Mason Fletcher?
No.
Kate Kinn?
No.
Sharon Hannick?
No.
Caleb Heimlich?
No.
Elizabeth Ferreira? No. Billy Joe Heatherington?
No.
Jake Hunter?
No.
Kelsey Barons?
No.
Thanks, George. Why explain you?
Alright, I have 2 in favor, 18 opposed, and 1 abstention.
Okay, so that fails. We will now move on to C-42, eminent domain, on page 83 of your packet. Mr. Rydell Kelly, do you have a motion for us?
I move to send C-42 to the hopper.
Do you have a second?
Second.
Mr. Consuelo seconds. Discussion on C-42, eminent domain, on page 83 of your packet. Commissioner, Commissioner Rydell Kelly, would you like to speak to your motion amendment?
Yeah, it's late. There's been a lot of discussion about this. There's been a lot of public comment. I want to reiterate just a few core points with this. I believe fundamentally that eminent domain must be used in a very adjudicating, careful way. The language at the beginning of the first paragraph in my amendment actually changes it from shall be used to may be used, and then makes it explicit that eminent domain should be used in things that are in service of our poor, our needy, our infirm, and folks that are facing certain environmental conditions, and in many ways is actually, it could be interpreted as more limiting than the existing eminent domain language in the charter, which has been there for a very long time, and is really about things like easements and parks, and road construction, and this is, I think, directive to the county that it can still use eminent domain for purposeful development, for developmental purposes, without it being a giveaway to private development. It actually takes out some complex, redundant language in the first paragraph, and specifies that eminent domain can be used to deal with blight. I want to be very clear, working class families that own their properties are not the target of this and would not be subject to this. This is for folks that are speculating and have let property go fallow and let property go into terrible conditions because they don't care about it. And there's a 7-year process, and it is a court process. Every single instance of eminent domain ever in Washington State must go through the courts. None of this changes any of that, and it is a red herring to say that somehow it is a crazy power grab by socialist government. It is trying to make government more effective at taking care of our most vulnerable people, particularly when it comes to things like housing, and I think it just makes sense. But I'm going to leave it at that, and I appreciate folks for, it just happened that my amendments are all the ones at the very end of the night here. Thank you.
Commissioner Hamlet?
Yeah, Commissioner Hamlet, District 3. I want to raise a couple points. Number one, the distinction of shall to may is a distinction, but without a difference. At the end of the day, if the county is using eminent domain, whether you call it shall or whether you call it may, it's going to happen. So to say this is limiting eminent domain because we changed one word, meanwhile we broadened multiple categories, including adding the language of if it benefits the poor or the infirm, or adding an entirely new category defined as blight or those types of properties. So we're expanding the definitions of when it is allowed. You can't argue that you're at the same time limiting its use. And so I think the public saw through that. I think the voters are going to reject this if we send it to the ballot box because they don't want it to happen more. And you can say it's not going to apply to working class people and it's only going to apply to these speculators, but that's not the way it is written and that's not the way it would be applied. So for those reasons, I'm a definitive no.
Commissioner Roby?
Thank you, Madam Chair. Commissioner Roby, District 3. C-42 attempts to redefine or expand adverse possession through a charter amendment. This is fundamentally flawed and unlawful. It overreaches by granting the government new ways to seize private property without proper safeguards, violating core constitutional limits on government authority. Adverse possession is a well-established doctrine rooted in the state statutes and common law. Local charters govern municipal operation but do not have the power to rewrite substantive property law. This proposal invites disputes that would likely be struck down as beyond its authority. In addition, C-42 appears to empower the government to acquire or claim private property through mechanisms akin to adverse possession for purposes not traditionally recognized as valid public uses. This is an unconstitutional expansion. The U.S. Constitution 5th Amendment strictly limits takings, nor shall private property be taken for public use without just compensation. Eminent domain is not a blank check. Courts have long held it must serve a legitimate public purpose, not mere government convenience or novel public benefits invented by local measures. This sidesteps the takings clause and due process protections. C-42 does not alter the government's existing eminent domain powers. Instead, the use of permissive language like may unlawfully expands them. Constitutional text uses shall deliberately as a command that restricts and limits the government. Private property shall not be taken for public use without just compensation. Shall imposes mandatory obligations and boundaries on government action. It underscores that eminent domain is an extraordinary power to be used sparingly and strictly according to law, not expanded via charters that list permissive mays. This proposal does not strengthen communities. It overreaches the charter's authority. This proposal should not advance.
Commissioner Rohr?
Commissioner Rohr, District 6. I did Google something that one of the public commenters shared tonight, in that Pierce County voters previously voted on eminent domain in the charter. The current charter section 9.80 limits the county's use of eminent domain and states that private property may be taken only for public use. It also restricts taking for economic development. The key history is that in 2006, Pierce County voters approved a charter amendment restricting the county from condemning private property for economic development. One legal policy summary reports that the amendment passed roughly 70 to 30%. So I am strongly opposed to C-42. I do believe this, and I don't like using any inflammatory language, but I think it's dangerous. Private property rights are fundamental. Government may sometimes need to acquire private property for a legitimate public use, such as a road, a school, essential infrastructure. But that authority should be narrow, clearly defined, and used only when necessary. C-42 would move Pierce County in the opposite direction. The proposal would expand the definition of public use and create a new section called implied adverse possession. It would allow the county to take property that it determines has been abandoned for at least 7 years. The definition is broad. It includes situations in which vegetation repeatedly encroaches on neighboring property or a structure becoming unsafe or unsound. The county could then restore the property or transfer it to another private party for restoration. Think about your neighbors, the people in our county. An elderly homeowner may need to move into assisted living. A family may inherit a home after death of a parent or face lengthy probate process. A person may be dealing with illness, financial hardship, and another financial crisis may not be able to complete major repairs immediately. And I give these examples, but I know that we all know people that are experiencing this. This is not uncommon, that people don't have the resources to make improvements to their property, and I think this has the potential to be very harmful. These conditions do require action, but the county has an abatement, code enforcement system for that, which is the proper channel. The county may need to require cleanup, repairs, or other corrective measures. But that is not the same as giving the county a broader path to take private property and transfer it to someone else. The proposal also adds broad language allowing eminent domain for the support of the poor and infirm and to protect the safety, health, and well-being of residents from hazards caused by neglect. Those terms are not clearly defined. What qualifies as a threat to well-being? How much neglect is enough? What does it mean for a condition to be permanently reversed for a substantial period of time? What safeguards would protect a property owner facing illness, financial hardship, or family crisis? Neglected properties can create real problems for neighbors, but the county already has tools to address unsafe structures, nuisance properties, and code violations. If there are gaps in the county's current enforcement tools, those gaps should be identified and addressed thoroughly through ordinance after legal review. John Locke wrote that people form government for the mutual preservation of their lives, liberties, and estates, which he described as property. This is not the place for symbolic gestures. This proposal would expand government power over private property in a way that is broad, unclear, and unnecessary. Think carefully about your neighbors and the kind of county government we are creating. Do not move this proposal forward. I urge a no vote.
Vice Chair Lentz?
Thank you. I'm not in favor of moving this forward, and I'm going to be a no vote, but I did want to point out a couple of things. What this proposal does not do is change the legal nature of the eminent domain process. What it attempts to do is to broaden the statement in our charter that defines what public use is, which would justify the taking. And it broadens that, but it doesn't do away with the notion that every eminent domain case is considered on its own merits and subject to challenge, and a court would have to find that the particular proposed taking the particular circumstances actually do constitute public use as is defined either here or more to the point in the state constitution. And also, the state constitution delegates, and state law delegates the eminent domain authority to counties. Many jurisdictions, in fact, Pierce County itself up until 2006, simply stay silent on it and allow public use to be defined as has developed in case law and in state law. In 2006, the voters chose to constrict the nature or the definition of public use in the case of Pierce County. Again, it doesn't change the nature of eminent domain and all of the things that have to happen. All this proposal tries to do is to broaden the definition of public use to look to that earlier constriction from 2006 and broaden that definition to include necessary support of the poor and infirm or for health, safety, and welfare considerations. So I just felt compelled to speak because I think there's a misrepresentation of the notion that this somehow does something different with how eminent domain works when all it does is intend to broaden the definition of public use from what we as voters constricted in 2006. So I'm not going to be voting for it. I've already spoken with Commissioner Kelly about it. I find some intriguing possibilities to this, but I think we're too late in our process to get to the bottom of it, and it's too controversial to be given the debate that I think it deserves and the legitimate discussion about the pros and cons of this. I just don't think we have time for it, but I felt compelled to speak to what the law requires and what it doesn't.
Commissioner Willis?
Commissioner Willis, District 3, I can definitely, thank you, Madam Chair. I definitely appreciate the commentary towards definitions from Commissioner Lance, because I love definitions. Part of Pierce County's public code actually defines, this is quite interesting, code enforcement pages define maintenance or safety problems as weeds and grass taller than 24 inches. So I'm not a fan of eminent domain. I believe in personal property rights, and I think that if we were going to take property, I think we should be paid full property value for that, which I propose an amendment that is true. But other than that, no vote for me.
Seeing no additional discussion, we will move forward with a roll call vote to move C-37, no, C-42, eminent domain, onto the hopper for final consideration.
Justin Layton?
No.
Brenda Likens?
No.
Brenda Molesky?
No.
Jerome O'Leary?
No.
Holly Rogie?
No.
Pujana Roar?
No.
Devin Red Kelly?
Aye.
Troy Surratt?
No.
Jen Reed Strickling?
Abstain.
Justin Willis?
Name.
Lisa Boyd?
No.
George Consuelo?
Aye.
Mason Fletcher?
No.
Kate King?
No.
Sharon Hennick?
No.
Caleb Hamlet?
No.
Elizabeth Rivera?
No.
Billy Joe Hedrington?
No.
Jake Hunter?
No.
Mark Lance?
No.
And Kelsey Barrett?
No.
I have 2 in favor, 18 opposed, and 1 abstention.
So that fails, and we'll move on to P-7, campaign finance, on page 85 of your packet. Commissioner Red Kelly, do you have a motion for us?
I move to send P-7 to the hopper and get tonight over with very quickly.
Do I have a second?
There we go.
Commissioner Hammack, is that a second?
No.
Sorry, your hand was up, so I wanted to ask. So without a second, P-7 is out of consideration. On to P-2, qualifications for office on page 88 of your packet. Commissioner O'Leary, do you have a motion for us?
Yes, I move to move P2 to the hopper.
I have a motion to move P2, qualifications for office, onto the hopper for final consideration. Do I have a second? Second. I have a second from Commissioner Roby. Commissioner O'Leary, would you like to speak to your motion?
Sure. This is, we've talked about this before. This is backed up by a case decision, and in my mind, this is what the charter is to do. It's to amend and to update. And I think this is a perfect example of something that has legal backing and should be modified. And I think it's in the best interest of the citizens to take this to them for a vote. Thank you.
Any discussion for P2? Commissioner Roby.
Thank you, Madam Chair. Commissioner Roby, District 3. I support P2, which removes unnecessary barriers to running for Pierce County elected office and aligns with the recent Pierce County Superior Court ruling. The current charter requires candidates to be residents and registered voters in their district for at least 1 year prior to filing. This goes beyond state law, which generally requires candidates to be qualified electors, U.S. citizens eligible to vote in the relevant district. The law doesn't mandate a full year of prior voter registration on top of residency. Pierce County Superior Court judge ruled that the 1 year residency requirement already served the compelling government interest in ensuring candidates are familiar with the communities. Adding a separate 1 year registration hurdle provides no additional meaningful protection and creates an unnecessary barrier that can exclude qualified candidates. I am supportive of removing barriers for qualified candidates, so I support this proposal. RCW 42.04.020 says you must be a U.S. citizen, and then another RCW at filing must be a registered voter and possess all qualifications specified by law for office. This amendment does not eliminate the requirement for residency or that you have to register for vote. It just eliminates that both of those require the 1 year requirement. So I'm a yes vote. Thank you.
Commissioner Surratt.
Commissioner Surratt, District 5. I'm going to be a no vote on this amendment. The language in the charter right now has been in the charter since 1980, since the beginning, and that current language is not an accident. For better representation, our voters have long required that candidates live in their district for 1 year and that they be required to be a registered voter in that district for 1 year. And subsequent charter review commissions have never sought to delete that language. Anyone can claim that they have lived somewhere for a year. Voter registration is the simple, objective public record to support that claim. And that's why our home rule charter has both. One helps verify the other. The proposal here strangely keeps the residency requirement, but it deletes the clearest way to demonstrate that it has been met. That doesn't make any sense to me. We should expect our candidates to follow our charter, not work around it. Candidates should know its requirements or find out before they file for a seat. And if we are to have good governance in Pierce County, we need candidates who are compliant with the charter that they will soon swear to uphold. Pierce County voters have long understood that they do not want carpetbaggers claiming their council seats. And one court's opinion is insufficient to gut this qualification that the voters have adopted. There's been no review by an appellate court, and there is no binding precedent here. So until we know it is actually unconstitutional, let's respect voter choice and uphold and enforce our charter. And two other points that I am kind of grappling with here. There's a little bit of a story momentarily, but Article 9 in this charter has a very clear conflict of interest clause. And that conflict of interest clause is again clear that employees cannot serve on Charter Review Commission. And in 2016, employees were allowed to do so, in violation, in my opinion, of the charter. Now, our commission is retreating from that and exploring allowing commissioners to serve on future Charter Review Commissions. This is wrong. I mention this because the rationale for this proposal talks about enhancing clarity. No, clarity is achieved here by simply upholding our charter. And the charter is clear: 1 year residency and 1 year voter registration requirements. And the other thing I'm considering too, this tension, is that our body has just rejected expanding the council, which is something I support. I do think that just better representation in our council districts kind of circumvents the need to expand at this time. But we get better council representation through this duo of qualifications. That's how we get people who know our council because they've been there for a year, and they can relatively prove so with their voter registration requirements. So I'm a strong no vote for this, and I encourage all commissioners to uphold the charter that we have been sworn to uphold.
Vice Chair Lenz?
I just wanted to add that I'm also a no vote on this for the reason that I think it's a premature solution. Echoing a little bit of what Commissioner Surratt said, there's not been a true finding that the 1 year residence or the 1 year voter registration requirement is in and of itself unconstitutional. There was one Superior Court judge who made a finding in one single case, and what that judge said was that 2 things were too many, and left the residency, because it wasn't an issue in the particular case, left that intact. While we've heard from the elections folks from the auditor's office and a number of different ways that the residency requirement is actually difficult to ascertain, and that the auditor is actually only checking for registered voters. So it seems to me that if you're going to have a requirement, it should be one that is objective and easily verified, as opposed to the residency requirement. So it strikes me that we have a proposal in the hopper that moves to enhance the residency requirement for running for county council to 5 years. So I think it's premature to take this one out, and I'm going to vote no to advance this for that reason.
Seeing no additional discussion, we'll move on to a roll call vote for the motion to move P-2, qualifications for office, on to final consideration.
Brenda Likens,
Abstain.
Brenda Molesky,
Yes.
Jerome O'Leary,
Yes.
Holly Roby,
Yes.
Rajana Rohr, Devin Rodell Kelly,
No.
Troy Sarad,
No.
Jen Marie Strickling,
No.
Judson Willis,
Yay.
Kelsey Barons,
Nay.
Lisa Boyd,
No.
George Consuelo,
Nay. Sorry.
Mason Fletcher,
No.
Kate Kinn,
Nay.
Sharon Hannick,
Yes.
Caleb Heinlein,
No.
Elizabeth Ferreira,
Yes.
Billy Joe Hudrington,
No.
Jake Hunter,
No.
Martha Lance,
No.
Justin Layton.
No.
I have 7 in favor, 13 opposed, and 1 abstention.
All right, that item fails, and so that concludes our proposals for the evening. I would entertain a motion to
Motion to close.
adjourn. I have motion to adjourn and a second. All in favor, please say aye. All opposed, please say nay. Abstentions. Meeting adjourned.